My name is Jenny Lank of Bloomsbury Professional, and I'm here with Michael Humphries QC of Francis Taylor Building, the General Editor of the National Infrastructure Planning Service. Michael, I'd like to talk about funding statements under the Planning Act 2008. First of all, what is a funding statement and why is one needed?
Right. Under the previous legislation, the sort of compulsory purchase code, as we would typically call it, it was always necessary when you were compulsorily acquiring land to demonstrate that you had the resources, both to pay compensation for landowners whose land's been taken and also to implement the scheme. Now, when the 2008 Act came in, what they did in effect was to formalise that by requiring a developer whose draft development consent order does include the compulsory acquisition of land, requiring them to provide a funding statement which deals with exactly those issues, the resource implications of actually acquiring the land and implementing the scheme.
And how are examining authorities scrutinising these funding statements throughout this process?
Well, pretty closely, to be frank. I mean, they are taking a very close interest in the funding statements and the way in which developments will be funded. And there are a number of reasons for that, including the implications for the Human Rights Act of taking people's land and being able to provide the necessary compensation so that their human rights are properly protected and that any taking of land is not a disproportionate interference with their rights. So they're scrutinising them very closely. I mean, some might actually say in some cases slightly overzealously. So taking an example of one National Grid project where, having provided their funding statement, they were then asked specifically to provide a letter from the finance director of National Grid to confirm that they have the money to pay for the scheme. Well, they are the national transmission licence holder. Of course they have the funds. So I think there's a little bit of bedding down perhaps going on in the system, but the funding statements are certainly being looked at very closely indeed.
Can you tell us what exactly is needed in a funding statement?
Well, a number of things. I mean, the most obvious things, as I've mentioned, are a statement that the resources will be available to pay the compensation for the compulsory acquisition, and that would include blight. Also that the funds are available or will be available to actually implement the scheme itself. But beyond that, there will be other things, and these are all covered in one of the articles that we've written in the National Infrastructure Planning Service. Other things will include, the sources of that funding, the timing of the funding, whether there is anticipated to be any shortfall in the funding, and if so, how that's going to be covered. So matters of that sort to give the examining authority and ultimately the Secretary of State confidence.
Okay, so some of this brings to mind compulsory purchase compensation. Is it relevant at all to this?
It's an interesting point. I mean, the simple answer, I suppose, is no, the compensation on any particular site is not relevant. That's a matter, ultimately, if not agreed, for the Upper Tribunal Lands Chamber. However, some objectors to schemes have said, well, look, how can you know that the funding is adequate if you don't know what the compensation is likely to be? It seems to me that examining authorities are going to be unlikely to want to get into questions of the compensation on any particular site. But what they might want is a feel generally for the overall level of compensation for the entire scheme, and that funding is in place to meet that compensation.
Right, okay. And what happens in the case where a promoter is a single-purpose vehicle?
Well, this is obviously an issue, and one of the issues that the examining authorities have been quite interested in. It's very normal for very large companies, when promoting a particular project, to create a special purpose vehicle to take that forward, a separate company, subsidiary company that takes something forward. Sometimes as well that's because there are joint ventures between two companies and they create a single purpose vehicle to take forward the particular project. The problem is that that single purpose vehicle may not itself have significant funds. And so in those circumstances, examining authorities are sometimes concerned about that for the reasons we've discussed, and will require the single purpose vehicle to provide parent company guarantees so that the parent company, usually the large PLC, is liable for the compensation in default if the single purpose vehicle isn't able to meet its commitments.
We may have planners, developers, or in fact legal practitioners listening to this today. What can you tell them about the service and about how having a further look into it might help them more with funding statements and other such related topics?
Well, it's clearly a very complex area, an area that is almost certain to be closely examined by an examining authority. There will normally be written questions posed by the examining authority in their first round of written questions, and really promoters and their advisors need to make sure that they are covering all the points they need to cover. Now, what the particular article does, and this particular one was written by James Pereira from Francis Taylor Building, what it does is examine the issues. It pulls in references to relevant legislation, guidance and so on, and gives an overview from his perspective, which is one of having dealt with these issues, of the sorts of things that are going to come up and the sorts of things that promoters need to cover.
Thank you very much for your time, Michael.
Thank you.